Bennett, I am very concerned. What was your intent on saying that?
My intent in this.
I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your ex.
She reached out to a friend of my client.
Call her to show up to do what?
Today, to say I'm afraid. I mean, I will say.
Mr. Bennett, you've been doing this long enough. You know that's not going to happen. That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and on behalf of James Dennis Whitley.
This is people's emergency motion to modify violence in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client.
Call her to show up to do what?
Bro, this hearing goes from 0 to DEFCON 1 in seconds. The prosecution says the witness is scared, and instead of easing into it, defense counsel fires back that the court is playing favorites. Nah, did he really want to test that theory today? Chuckle look at the judge's face. That smile disappears fast, shoulders tighten, and you can almost see the patience leaving the room. Wait, because the next response is absolutely nuclear.
Today, to say I'm afraid. I mean, I will say.
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong.
The judge came back from recess with receipts. I mean, this wasn't a lecture. This was a full courtroom reality check. He's basically saying, I've been on this bench for decades, and don't tell me I play favorites. Look at his expression. Calm voice, locked eye contact, not even blinking. That's the scary kind of angry. Then he gives the attorney more time instead of punishing the client. Wait, but this courtroom drama is only getting started.
Court's going to stand in recess.
All right. Have you seated? 14A District Court of County, Washington, out in session, the hour of J. Settings.
You may be seated. Court recalls the case of the people versus Whitley.
Assistant Prosecuting Attorney wants to so much on people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton on behalf of Mr. Whitley, who's standing to my right. You'll make me state your name before, please. James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No. My turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing.
So the judge could have let emotion take over, But instead, he hit the brakes and protected the defendant from his own lawyer's mistake. That's the difference between being upset and being fair. I mean, respect where it's due. But don't get comfortable, because the next hearing is about to reveal something that makes everyone in the courtroom stop and stare. Trust me, you won't see this coming.
To be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it, because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client.
Hold on. Did I hear that right? The judge just revealed there's talk that defense counsel threatened to file a grievance against the prosecutor if this hearing moved forward. Bro, that's not the kind of sentence you casually drop in courtroom. Look at the judge's face, eyebrows raised, leaning forward, choosing every word carefully. You can feel the tension building. And now, he's about to demand an explanation that changes
By what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow.
I mean, this is where the defense tries to explain the whole thing, and somehow it keeps getting more awkward. He's saying he believed the prosecutor wasn't meeting ethical obligations, then immediately starts walking parts of it back. Wait, so is it a serious ethical violation or not? Chuck will look at the judge, barely moving, just staring him down like he's waiting for one answer that actually makes sense. And trust me, the follow-up questions are brutal.
Discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that, unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings, and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point, to certainly bring it to the court's attention, which I think is appropriate, since it's under Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so,
Nah, the judge is picking this argument apart one piece at a time. Every explanation gets another question. Every answer opens another hole. I mean, it's like watching someone dig while insisting they're climbing out. Look at the judge's expression. Calm, almost puzzled, with that slight head tilt that says, you really want to stick with this? Then comes the moment where this stops being about legal strategy and gets very personal.
for you to state on the record what that offense is.
My concern,
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No,
Was that said to the prosecutor?
that was said, I don't believe it was said in the manner that was described at the bench, but certainly
Then tell me how it was said.
there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe.
Bro, here's where the temperature in the courtroom hits maximum. The judge makes it crystal clear that nobody is going to intimidate attorneys in his courtroom. That's not a suggestion, that's a warning. Then he calls the conduct inexcusable and even SCNCINABLE. Look at the judge's posture, leaning forward, voice steady, eyes locked in. That's the look that says he's completely serious. But wait, the attorney's next response somehow makes this even worse.
I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why don't we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Is that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it said?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in front.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no.
Wait, instead of ending the debate, the questions keep coming, and every answer sounds shakier than the last. The prosecutor calmly explains her side, while the judge keeps circling back to one thing. What was your intent? Oof, that's the question nobody wants to hear. Look at the judge's face, completely composed, but every word lands harder than the last. Then comes the line about walking on real thin ice. And after that, nothing feels safe anymore.
No statements to Mr. Bennett about Ms. Potter being present. I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
Why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
After that recess, the whole vibe changes. The attorney stands up and says he'll self-report. That's a sentence you do not hear every day. Chuckle, but the judge isn't ready to let this go just yet. He's basically saying, we'll see about that. Look at the judge's expression, calm, measured, but still giving that unmistakable, I'm not finished with you stare. Wait, because the courtroom still has actual business to handle.
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. That behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. and you,
I did not.
if you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this. Right.
She took it as a threat. What was she supposed to take it as?
I mean, after all that drama, everyone has to switch gears like nothing happened. Now, they're talking witnesses, identification, and scheduling. It's almost funny how fast the courtroom goes back to business. Look at the judge, relaxed compared to before, but still completely in control of every word spoken. So you'd think the tension was over, but one final decision is about to wrap this entire mess together.
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule?
I felt this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
My intent in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, you know.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do.
Bro, the hearing finally lands the plane. A new court date gets set, the attorney promises to keep the court informed, and the judge officially adjourns everything. No yelling, no fireworks, just one last reminder that today's biggest story wasn't the criminal case at all. Look at the judge's body language, composed, collected, already moving on. But the lesson from this courtroom is going to stick with everyone watching.
But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess.
All rise. Hey, District Court, for County of Washington, State of Michigan is now back in session. The hour of today's session.
May be seated. Back on the record in case of the people State of Michigan versus Whitley. Counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes.
Nah, what started as a criminal hearing somehow turned into a masterclass on courtroom professionalism. The spotlight shifted from the defendant to an experienced attorney who pushed things way too far. The judge never let emotion control the outcome, but he also made it clear that respect inside a courtroom isn't optional. I mean, every word carries weight. And that's exactly why this hearing became unforgettable.
And I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification, and I would...
As to identification of...
defendant. So it's very brief, and I don't want to have to bring the lay person back.
Understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
And just like that, it's over. One comment, one confrontation, and an entire hearing took a turn nobody expected. Bro really found out that courtroom credibility can disappear fast when you test the judge's patience. Chuckle if you enjoy real courtroom moments, sharp judicial showdowns, and legal drama broken down with reactions like you're watching with friends. Hit like, subscribe to Case File USA, and I'll catch you in the next case.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only...
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as the prosecutor if you're going to self-report so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned. July 1st, 2024, 10 a.m. before me. Thank you.
Thank you.